Ian, thanks for joining us today.
Sure.
You're going to guess what my first question is going to be. Before IPXI and before Blackstone and before now University of Kentucky, how'd you get into this field?
Yeah, well, we've had some great stories actually so far from the panelists on how they got into this field. Mine is quite different, like many people in the IP space. I didn't have the natural path as with a technical background or as an engineer or through patent law. I have sort of a markets background. I was an economics major in college, and then I went to law school, and I was sure I was actually going to be an IP attorney, but not in this field. I was sure I was going to be an entertainment attorney. When I was at Vanderbilt as an undergrad, as an economics major, I interned at Warner Brothers Music and Sony Music ATV Publishing, and was sure that was the path I was going to take. But similar to John, when it came down to actually getting job offers from law firms and having to pay some of the loans back and things like that, I went a route through to corporate transactions. I was given an offer by a law firm to join their corporate M&A group, and off I went away from IP, and that was it. So I started doing corporate transactions work, and which was fine. I was with the law firm for a couple of years, and then I worked on a large acquisition or merger between two large energy companies that failed because the two sides could not agree on the value of the intellectual property involved in the deal.
And I killed the whole transaction.
Killed the whole deal. I billed countless weekends and Friday nights. Literally, I billed almost an entire year to this deal to learn, that in the 11th hour it was not going to happen. And I was beside myself because I couldn't believe that in fact, the two sides were literally hundreds of millions of dollars apart. And I couldn't believe that was the case. So I wrote an article and I took it upon myself and I said, there's got to be a better way. Is there really no marketplace? Are there really no standards or course of dealing? Is there not a market price? How do we do this better? I wrote the article, thought nothing of it, and then got a call one day from someone who was going to start a company that was going to be a marketplace for IP. And I really, really believed in the idea and the efficiencies that it was going to create. And we've had a great lead up of discussions here towards efficiencies around markets and patent pools, transaction efficiencies, pricing efficiencies. And that was how I got in. So I left the law firm, started the company, and off I went into the IP space.
So actually, and this is where I first met Ian when you came and pitched us to join as one of the founding members of this crazy idea, IPXI, the Intellectual Property
Exchange International.
Exchange International. And I think for those of us who've been in the field for a while, this was almost like a fairy tale. It's the idea of we all struggle with complete lack of transparency and deals take forever and both sides are afraid of the repercussions and there's holdout problems and there's pricing issues. And then in walks Ian and his partners with this beautiful idea. And it really was a beautiful idea. So if we could, I've sent some articles around, I'm not sure if everyone read them. Could you just give us what problem was IPXI formed to solve?
Sure.
And what was the concept?
Sure. So we've heard a lot of people talk already. Garrett talked about the inefficiencies in holdup and royalty stacking and having to get multiple licenses from different people. We heard some of the issues that John had, or actually how those problems were solved by doing sort of a public auction, or not a public auction, but an auction setting where you had at least some price transparency. We were really setting out to solve the issue of doing a transaction where the value of the transaction truly resembled the value of the assets involved, and not bargaining position, not who could pay for litigation or not, and how do we actually find the value of this deal, and a value that's going to be the correct value in 5 or 10 years. So if you negotiate a royalty of 4%, 4% today could be $1 and 4%, or 20% of your operating margin, and 4% in 5 years might be 80% of your operating margin, and there's no way to know that today. So how do we do this better? So what we set out to solve was how to create those efficiencies through transparency, additional transparency. Licensing and intellectual property transactions is an incredibly clandestine market. Imagine trying to buy or sell your house without the MLS, Redfin, or any other website that we have today that can tell you the value of homes around yours in your neighborhood. It would be very, very difficult. Imagine the friction that would happen today if you tried to do a transaction for real estate without knowing what the value of the other buildings or houses on the block are. But that's the reality today in the IP space, because most of it is done behind closed doors and under confidentiality, and even in the case of public companies, most of it, at least the important details, are never disclosed, and so there's no way to know. So we set out to try to create a market price and a marketplace in which we could create a market price with a standard course of dealing, transparency of diligence items, and transparency of price, and it was a challenge.
So the idea was that this would be based essentially off the options markets, right? And that, in fact, is where some of the founders came from?
Yeah. It's where we actually got one of our strategic investors was the Chicago Board Options Exchange, CBOE, which is the largest options contract exchange in the world. And truly, we were a financial exchange model, and maybe that was one of our downfalls, to be honest, because we were looking at the ability, down the road, the ability to create futures contracts and options contracts out of technology and IP. I mean, think about it. The way we viewed it from a markets perspective is if you can create futures contracts for a commodity, cereal, grain, oil, and you can trade on the future value, future price of those commodities, why can't you do that with technology? Because if we truly don't know what the value of a technology or IP is today, and that value is not going to come to fruition until 5 years, 10 years from now, why can't we create a commoditized right to use the technology? You can't commoditize a patent. Every patent is different, but you can commoditize the right to use the patent through a standardized license. And that's what we did. So we set out and we created these products that could be traded in a secondary market even through a financial exchange platform. And that was the idea.
So to make this tangible, I mean, some of you folks here may have played around on the internet with things like prediction markets for elections, or prediction market, or like I think there's one where you can trade the value of a celebrity by their box office returns, and it's sort of, the theory is interesting because it allows the asset owner there, in a sense, to get a sense of what the wisdom of crowds might have to say about what is inherently an intangible asset and one that's very hard to price. The difference there is that in those markets, the people buying and selling those are using funny money, and they don't get to actually have any connection to that celebrity or the election any more than they did before they played. In your case, you guys had an extra struggle of saying this should be traded like corn or wheat. But like those commodities, the people buying those assets need to have the right to use those assets without fear of litigation.
Right.
And what I thought was brilliant about what you tried to put together was this concept. We've talked about royalties. We've talked about upfront fees. They came up with something called the unit licensing right, or ULRs, which we did not cover because it is not a standard approach for doing this. But it is for commodities. So could you explain the ULR?
Yeah, so I touched on this a couple of minutes ago. With royalties, oftentimes you get, let's just say you come to an understanding of, okay, we'll agree on 3% of net sales, which is, and your royalties are usually based on net sales instead of some margin, operating margin, profit margin. So 3% of net sales today, the NPV of that might be something totally different in 4 or 5 years. And one of the problems in licensing is that because margins might change and technologies can become obsolete, when you do a license and you want to continue to get that royalty stream, you have to, implicit in that license is facilitation of the continued use of that technology and product. And if you are the licensee and you do a license for 3% of net sales, and that works for me today, but actually in 3 years that eats my margin and I can no longer implement this technology, I'm just going to stop doing it. That hurts the licensor, the owner of the technology, because they no longer get the royalties because I just can't do it anymore, right? So a license has to facilitate continued use of the technology. So we tried to fix that and turn it on its head, and instead of trying to agree on some arbitrary percentage of net sales today. We actually did the math based on today, based on an NPV value of what a 3% royalty would be today. We just gave that a number. We gave that a price. And we said we're going to sell these units where a license is on a per unit basis. So we'll just call the unit a smartphone. Per smartphone, if a 3% royalty on net sales on a smartphone today based on margins and everything was, let's just say $1, we'll just sell them each $1 a piece. Instead of the license being over time, over a period of time on net sales or percentage of net sales, you would just buy on an as needed basis. Okay, next quarter we're going to ship 100 of these, so we'll buy 100 units today. And the quarter after that, we'll see how many we ship, and we'll buy another 100 units.
But the amazing thing about that, I mean, if you just pause for a second, when we talked earlier in the class about what a license does, a license allows the licensee to use the patent to make their products. And typically, you would take a license that allows you to make generally, not always, but generally, as much of this as you want. Because you're going to invest all this money in R&D and then be able to churn out the products that are now making you money. At least, you could maybe have it a limited time. But in this case, you actually specifically the idea was that people would buy only as many of these ULRs as they needed for the immediate future, and then buy more or less at a price to be determined in the future.
Right.
And I guess fundamentally that's predicated on the idea that these companies are confident that they will continue to have access to these ULRs.
Right.
So when you went out into the market and started, you launched, you had 3 offerings?
Correct.
3 different technology offerings. What was the reaction you got from companies?
Yeah. So I can say on the supply side, it's intuitive. We had a lot of support and licensors, owners of the technology and the IP rights, wanting to find a different mechanism to do this.
Such as who?
We had global technology companies. We had universities, even like Columbia, that were involved in this exchange and were willing to put their IP into these offerings. The issue was and something that you just said is something that we were naive about, and that is actually we saw a license the way you just said it. It gives somebody the ability to do something. What we overlooked is really what a license is the ability to do something without getting sued. So we're not licensing somebody and giving them the right to do it. We're just saying you can now, it's like a covenant not to sue. Now we're telling you, you just won't get sued. You can continue to do it without getting sued. What we really misstated and we were misguided about is on the buy side, there was truly, and what is continues to be exacerbated by a lot of things that are coming out of the courts, is efficient infringement, right? And it's sort of a cost equation. When companies decide to go into a market where there's thousands of patents that they know that they don't own and may be stepping on, the decision to go forward and create that sort of corporate footprint is generally a cost equation and an equation of probabilities. Because patents are probabilistic in nature, they're probabilistic rights. They're not automatic, right? Just because you have a patent doesn't mean you'll have it tomorrow. It can be invalidated. We've seen in the past decade the ability to invalidate some patents has become easier through different mechanisms, and that sort of just swings the pendulum in favor of the licensees or the defendants in litigation, and it swings that cost equation towards the probability of being sued as being lower. And so that when you look at that cost equation, their comfortableness, their confidence in being able to continue to make a product without getting sued has become greater, and they've continued to do it. And so that's when we got into the market with this open market platform and transparency and a lot of other things we were trying to build, companies just didn't care.
Yeah, actually, and so Gerard Patacook, the founder of the CEO?
Yeah.
CEO of the company, said in an article, Gerard said, the quote, "The fact is we were unable to achieve the last milestone. We could not get a significant number of entities to be good corporate citizens and respond to legitimate licensing offers, where we had done 90% of the work in advance for them. They could go into our data rooms and find detailed information on prior art, evidence of use, claim charts, applicability, validity, and so on. But in the end, that did not suffice." Is that?
Yeah.
I don't mean to be dredging up bad memories.
Well, it was a really interesting time. We learned a lot. I would say maybe not 90% of the work. We did a lot of the work that that two entities would do in a license negotiation that sometimes can be so protracted. It's multiple years that they do a lot of this diligence work. John mentioned a couple of things that are so important when you look at a patent and try to determine its value, and that's not just on the face of the patent, but you need to know who's licensed and what's the prior art known out there. So those are the things that we did. We put into a data room. We didn't say, because of confidentiality reasons, who is exactly is licensed, but we said sort of the market share that is already licensed. So we would say 40% of the market is licensed. So you can get a good idea if you look at the overall market, the licensable market, and then understand that 40% is already licensed. Just take 40% of the licensable value away. So those types of things we did. What we tried to do is put as much of the stuff that any licensee says they have to have in order to make a licensing decision, out in the open. So not just any particular licensee can see it, but all of them can see it. And then most importantly, the bids. So John talked about the Nortel auction. One of the reasons it was such a success is because you had, it wasn't a perfect competition market, but it had indications of a market that made it work. Some price transparency. Companies got to see what other companies were bidding and react, and that's truly what a market is. And so we did that. We had a bidding process. If you submitted a bid, we'd post it, and you could see sort of what a willing buyer and a willing seller were ready to pay for a license.
So one last question, but it's sort of a philosophical one. Looking back on this now, which really was, from my perspective, one of the most innovative, creative, and optimistic, in a positive way, optimistic approaches to trying to solve some of the gridlock that we see in licensing. Looking back on it now, if you could do it over again, were there things that you feel like IPXI got right and things that you would do differently? Or in the end, was this just not a solvable problem via the mechanism you tried to take?
Yeah, it's tough. I think about this a lot. We did something. We had some concepts right. Additional transparency, militating towards a market price with the greater transparency. What we did wrong was we conflated that. We confused the market a bit with the secondary market. We were too complicated in trying to infuse this financial exchange already. We needed to focus on the primary market before we could develop the secondary market. And companies truly didn't understand the whole bidding, not the bidding process, but the ability to trade these contracts. What's an option? What's a market? I mean, it's tough to convince the IP world about markets and vice versa. And so I think we had a few things right, and that was generally just the concepts of increased transparency, the ability to do market pricing, and just kind of the market as a whole. And other marketplaces have been attempted, right? We weren't the first to do that. There have been sort of portals, right, that increase the visibility. But I think what we took it to a next level was around the pricing, so transparency of pricing and the ability to increase predictability in licensing.
Some of the tools that Garrett mentioned, the standard essential patent pools have managed to do with a still complex, but maybe not the same level of complexity.
Yeah.
Great, Ian, thank you.
Thank you.